Hello, I'm Kon Yoon, a professor at Hanshin University. Today's topic is privacy issues in the data-based government. In a democratic country, privacy issues are treated with great importance from a human rights point of view. So, what does privacy mean in the context of data-driven government? In this lecture, we will explore privacy issues in data-driven government. As the data age progresses rapidly, the possibility of privacy violations is increasing. Currently, the governments are trying to strike a balance between the active use of data and protection of privacy. This lecture will examine the efforts of these governments through examples of the OECD, EU, and Korea. There are 4 objectives in this module. The first is to understand privacy issues in the data age. The second is to understand why privacy is important in data-based government. The third is to understand the OECD and EU privacy guidelines. The fourth is to understand anonymization techniques to solve privacy problems. The structure of this lecture consists of 3 parts: background, cases, and issues and key factors. New data technologies' emergence in today's data age are providing opportunities for a new leap forward. Nevertheless, concerns about personal data infringement that may arise as a result of the use of these new data technologies pose a challenge that can strike a balance between the development of new industries and the protection of personal data. The environment in which the traditional privacy principles are now implemented has undergone significant changes in the volume of personal data being collected, used, and stored, the range of analytics involving personal data, providing insights into individual and group trends, movements, interests, and activities. The value of societal and economic benefits enabled by new technologies and responsible uses of personal data. The extent of threats to privacy. The number and variety of actors capable of either putting privacy at risk or protecting privacy. The frequency and complexity of interactions involving personal data that individuals are expected to understand and negotiate. The global availability of personal data supported by communications networks and platforms that permit continuous multi-point data flows. Reflecting the demands of the times for the use of data, a new growth engine in the era of Fourth Industrial Revolution, 3 data-related laws were initiated in Korea on August 5, 2020. Personal Information Protection Act, Information and Communications Network Utilization Promotion and Information Protection Act, Credit Information Use and Protection Act. Currently, the Personal Information Controller can use the pseudonymous processing of personal information for the purposes of national statistics, scientific research, and public record preservation. This graph is about the identification and anonymization study trend in the biomedical literature. It can be seen that after a slight increase overall, it has risen sharply since 2016. According to the DBG Act in Korea, a public institution may request data to be provided to another public institution, and the requested public institution is required to provide it. However, the Act states the reasons for not having to provide. The first is when other laws require confidentiality. Privacy matters are directly governed by this provision. In other words, the institution requested to provide the data can refuse to provide the data in terms of the Personal Information Protection Act. According to a survey of DBG in 2019 by the Korea Institute of Public Administration, a prominent policy think tank institution in Korea, privacy issue is the most significant problem against data integration or data sharing for DBG. Here, we review OECD and EU cases to understand privacy issues in DBGs. The first is the case of the OECD guidelines on the protection of privacy. The privacy guidelines were launched in 1980 and revised in 2013. The revised text modernized the OECD approach and reinforced its integration with other work on privacy law enforcement cooperation. The review was developed in consultation with an advisory group of over 60 experts from governments, business, civil society, and academia. A number of significant challenges in implementing the privacy guidelines have been identified, especially against the backdrop of technological developments. In the wake of the COVID-19 crisis, calls have thus intensified for the OECD to champion a holistic approach to privacy and data protection practices. An approach that takes into account multiple societal objectives, including the collective and ethical dimensions of personal data processing. The OECD guidelines suggest 8 basic privacy principles applied within a country. Collection limitation principle is that there should be limits to the collection of personal data, and any such data should be obtained by lawful and fair means and where appropriate with the knowledge or consent of the data subject. Data quality principle is that personal data should be relevant to the purposes for which they are to be used and to the extent necessary for those purposes should be accurate, complete, and kept up to date. Proposed specification principle is that the purposes for which personal data are collected should be specified not later than at the time of data collection, and subsequent use limited to the fulfillment of those purposes or such orders as are not incompatible with those purposes and as are specified on each occasion of change of proposal. User limitation principle is that personal data should not be disclosed, made available, or otherwise used for purposes other than those specified in accordance with paragraph 9 except with the consent of the data subject or by the authority of law. Security safeguards principle is that personal data should be protected by reasonable security safeguards against such risks as loss or unauthorized access, destruction, use, modification, or disclosure of data. Openness principle is that there should be a general policy of openness about developments, practices, and policies with respect to personal data. Means should be readily available of establishing the existence and nature of personal data. and the main purposes of their use, as well as the identity and usual residence of the data controller. Individual participation principle is that an individual should have the right to obtain from a data controller or otherwise confirmation of whether or not the data controller has data relating to him. To have communicated to him data relating to him within a reasonable time, at a charge, if any, that is not excessive, in a reasonable manner, and in a form that is readily intelligible to him. To be given reasons if a request made under subparagraphs and A and B is denied, and to be able to challenge such denier, and to challenge data relating to him, and if the challenge is successful, to have the data erased, rectified, completed, or amended. The following are the principles that apply when personal information is applied in an international environment. Member countries should take into consideration the implications for others. Member countries of domestic processing and re-export of personal data. Member countries should take all reasonable and appropriate steps to ensure that transporter flows of personal data, including transit through a member country, are uninterrupted and secure. A member country should refrain from restricting transporter flows of personal data between itself and another member country except where the latter does not yet substantially observe these guidelines, or where the re-export of such data would circumvent its domestic privacy legislation. A member country may also impose restrictions in respect of certain categories of personal data for which its domestic privacy legislation includes specific regulations in view of the nature of those data, and for which the other member country provides no equivalent protection. Member countries should avoid developing laws, policies, and practices in the name of the protection of privacy and individual liberties, which would create obstacles to transporter flows or personal data that would exceed the requirements for such protection. So far, the OECD guidelines have been reviewed with a focus on basic principles for managing privacy. The next case is the EU GDPR. This is an EU regulation which is qualitatively different from the guidelines as a level recommended for OECD member countries. A comparison with the Data Protection Directive (DPD) 9546 is necessary to understand the EU GDPR. The DPD was adopted and implemented on October 24, 1995. It does not apply directly to EU member states as GDPR does. Individual member states must enact separate legislation based on the DPD. Therefore, there is a difference in the level of regulation between the laws of each member state. With the rapid advent of the Internet environment after the implementation of DPD, the need to reflect this increased rapidly. In this context, GDPR was born. It was adopted on May 27, 2016, after 4 years of discussion, and came into force on May 25, 2018, with a 2-year grace period. The difference between this and the DPD is that it is directly applied to all EU member states, enabling unified legal application and regulation among member states. GDPR is a unified, simplified framework suitable for the digital single market. It consists of a single set of data protection rules and also applies one interlocutor and one interpretation principle according to a one-stop shop mechanism. GDPR also expanded the rights of data subjects and strengthened corporate responsibility. Consent requirements for use of personal information have been strengthened, and the right of data portability and the right to be forgotten are included. And obligations such as designation of a DPO and notification of personal information leakage are imposed on individual companies. And GDPR has a more modern privacy governance system. The GDPR includes a system for cooperation among personal data supervisory authorities, the establishment of the European Data Protection Board to ensure consistency in the application of the law and credible and proportionate sanctions. GDPR consists of 11 chapters and 99 articles, and the main content is to strengthen the rights of data subjects and corporate responsibility. GDPR can be applied not only to companies operating business size in the EU, but also to companies that process personal information of EU residents abroad through e-commerce, etc. GDPR stipulates penalties for non-compliance. The maximum penalty is 2% of global sales for general violations or 10 million euros, whichever is higher, and 4% of global sales for significant violations or 20 million euros, whichever is higher. Here are a few highlights of the GDPR. First, the GDPR contains 7 principles on personal data and controllers. Personal data shall be processed lawfully, fairly, and in a transparent manner in relation to the data subject. And personal data shall be collected for specified, explicit, and legitimate purposes and not further processed in a manner that is incompatible with those purposes. Further processing for archiving purposes in the public interest, scientific or historical research purposes, or statistical purposes shall be in accordance with Article 89(1), not be considered to be incompatible with the initial purpose. Personal data shall be adequate, relevant, and limited to what is necessary in relation to the purposes for which they are processed. Personal data shall be accurate and, where necessary, kept up to date. Every reasonable step must be taken to ensure that personal data there are inaccurate, having regard to the purposes for which they are processed, are erased or rectified without delay. Personal data will be kept in a form which permits identification of data subjects for no longer than is necessary for the purposes for which the personal data are processed. Personal data shall be processed in a manner that ensures appropriate security of the personal data, including protection against unauthorized or unlawful processing and against accidental loss, destruction, or damage using appropriate technical or organizational measures. The controller shall be responsible for and be able to demonstrate compliance with the paragraph 1. The following are the rights of data subjects: transparency and modalities, information and access to personal data, rectification and erasure, right to object, and automated individual decision-making. Rectification and erasure includes right to restriction of processing, notification obligation regarding rectification or erasure of personal data or restriction of processing, and right to data portability. The following are regulations for controllers and processors. Taking into account the nature, scope, context, and purposes of processing, as well as the risks of varying likelihood and severity for the rights and freedoms of natural persons, the controller shall implement appropriate technical and organizational measures to ensure and to be able to demonstrate that processing is performed in accordance with this regulation. Where processing is to be carried out on behalf of a controller, the controller shall use only processors providing sufficient guarantees or implement appropriate technical and organizational measures in such a manner that processing will meet the requirements of this regulation and ensure the protection of the rights of the data subject. The controller and processor shall designate a data protection officer (DPO) in any case where the processing is carried out by a public authority or body, except for courts acting in their judicial capacity. DPO's tasks are to inform and advise the controller or the processor and the employees who carry out processing of their obligations, to monitor compliance with this regulation, to cooperate with the supervisory authority, and so on. When it comes to data protection impact assessment, where a type of processing in particular using new technologies and taking into account the nature, scope, context, and purpose of processing is likely to result in a high risk to the rights and freedoms of natural persons. The controller shall, prior to processing, carry out an assessment of the impact of the envisaged processing operations on the protection of personal data. Taking into account the state of the art, the cost of implementation, and the nature, scope, context, and purposes of processing, as well as the risks of varying likelihood and severity for rights and freedoms of natural persons posed by the processing. The controller shall, both at the time of the determination of the means for processing and at the time of the processing itself, implement appropriate technical and organizational measures such as pseudonymization, which are designed to implement data protection principles such as data minimization in an effective manner, and to integrate the necessary safeguards into the processing in order to meet the requirements of this regulation and protect the rights of data subjects. These OECD guidelines and EU GDPR are efforts to prevent the possibility of excessive data breaches due to the increase in data utilization. Among these efforts, we would like to take a closer look at the most important issue of data de-identification, anonymization, or pseudonymization technology. The de-identification process consists of 4 major steps. Step 1 verifies that the data is personal data. In step 2, it goes through the identification process that removes personally identifiable elements. Step 3 examines whether this de-identification is sufficient. These 3 steps process result in a final 4th step, de-identify the data. The detailed procedure is as follows. First, preparing basic documents is that a personal data controller shall prepare basic documents needed for adequacy assessment, such as a data statement, the identification status, and the management level of user organizations. Second, organizing an assessment panel is that a privacy officer shall organize the assessment and panel comprised of more than 3 people. Third, conducting assessment is that the assessment panel shall assess adequacy of the level of the identification measures using the basic documents prepared by the personal data controller and the K-anonymity model. Fourth, implementing additional de-identification is that the personal data controller shall implement additional de-identification measures based on feedback from the assessment panel if the assessment result is inadequate. Assessment by the assessment panel consists of 6 functions: preliminary review, analysis of possibility of re-identification attempt, analysis of re-identification impact, quantitative analysis, decision of reference value of assessment, adequacy assessment. First, the assessment panel reviews prepared basic documents and interview to check out whether personal identification elements are in a data set, whether the proposal of utilization and the identification methods are appropriate. Second, it analyzes possibilities of re-identification attempts, including intention, level of personal data protection, and capability of personal data controller who uses or receives the data. Third, it assesses a possible impact on a data subject when data is intentionally or unintentionally re-identified. Fourth, it verifies the accuracy of a K-value provided by a personal data controller. Fifth, the assessment panel determines the assessment reference value, K-anonymity value, by taking into consideration possibilities of re-identification, impact of re-identification, results of quantitative analysis, and purpose of data utilization comprehensively. Lastly, it decides adequacy of the identification by comparing calculated values resulted from the average reference value and quantitative analysis. These anonymization techniques are primarily important in data integration. Data integration is a keyword that penetrates the data era, and it increases the effectiveness of problem solving in the environment of policy convergence and becomes a key issue, especially in the use of AI for data. Let's take the case of Korea as an example. In Korea, the Personal Information Protection Act regulates the processing of pseudonymous information, together with data integration and specialized agencies. The process of data integration by these data integration organizations with pseudonymized information is as follows. In step 1, a person wishing to combine shall perform preliminary preparations necessary for the integration of pseudonymous information, such as preparing an integration application by discussing the matters necessary for the application, for integration among the applicants, for integration, and reflect the result and apply for the integration to the association or specializing in association. In step 2, an integration applicant who wants to provide pseudonymized information receives information used to generate an integration key from an integration key management institution, generates an integration key, and performs simulated integration, confirmation of the integration rate, and extraction of pseudonym information if necessary. After that, the information required for bonding is transmitted to each institution. In step 3, the applicant for the integration who wants to use the association information may perform additional pseudonymization anonymity processing in a separate space stored within the integration specialized institution before exporting these association information or perform analysis if the integration specialized institution supports the analysis function. In step 4, the applicant for the integration who wants to use the association information may perform additional pseudonymization anonymity processing in a separate space stored within the integration specialized institution before exporting the association information or perform analysis if the integration specialized institution supports the analysis function. In principle, exported information should be used within the environment and proposed submitted by the combined applicant at the time of expert review. The applicant for the integration may request the specialized agency to support the analysis of the exported information. After exporting, a specialized agency that supports analysis support must be tracked in the comprehensive integration support system and then applied for. It is not prohibited to use the information exported by the combined applicant for purpose different from the time of export review or to provide it to a third party, but if there is a change in the processing status submitted during the expert review, it should be used after reperforming the pseudonymization according to the processing situation. In the case of exporting after applying for a repeated integration, the repeated integration key is included in the export information. Combined applicants must not process exported information for the purpose of identifying specific individuals and must continuously monitor to prevent the applicant for the integration must not process exported information for the purpose of identifying specific individuals and must continuously monitor to prevent re-identification. When using exported information, the applicant for integration shall take technical, administrative, and physical measures necessary to secure safety. The content of this lecture is summarized as follows. In order to use the results of data analysis in policy, it is necessary to produce a lot of meaningful information. Individual level data enables the production of more meaningful information. However, individual level information constantly raises privacy concerns. Activation of data-based government and protection of privacy cannot be sacrificed either, and a third alternative that satisfies both is required. This is why the identification or pseudonymization technology is important in developing data-based government. De-identification technology is constantly evolving. The government needs a lot of investment in R&D for de-identification technology to overcome the privacy problem and complete data-based government. Data de-identification technology is mainly used especially in data integration. To solve today's complex policy problems, merging data from various sources is required, and data integration at the individual level raises privacy issues. This problem can be being solved through a specialized agency for data integration. Thank you for attention.